Is she? Please.
Okay. This. Put him in my shirt. Hey, Camel.
The body camera was meant to protect the truth, but this time it exposed it when 3 officers walked into a home for a routine eviction. The footage captured more than just law enforcement doing their job. It caught hands rifling through someone's belongings. Cash, electronics, even glasses. One officer's voice trembled. Later in court, she said she was following orders afraid of losing her job. What happens when a badge once trusted becomes the mask for grand theft, recorded by the very lens meant to ensure accountability? How could a camera built for transparency turn into evidence of a crime? In January 2021, a quiet street in Smith County, Texas, became the backdrop for that question. 3 officers, Chief Deputy LaWenda, Banks Constable Curtis Traylor-Harris, and Sergeant Derek Holman arrived for a routine eviction. The air was mild, the paperwork stamped and sorted, and the mission clear: secure the property, log belongings, and proceed in accordance with state procedure. Their body cameras clicked on flashing green, meant to record compliance and professionalism. But inside the quiet home, the law began to mutate the footage. First showed business-like movement, drawers opened, cabinets noted, then a phrase broke the rhythm. Banks's microphone caught it. Whatever you see, and you want it, take it. It wasn't a command to document, but an invitation. In that instant, the cameras stopped chronicling duty and began recording theft. The drawers were no longer being checked for safety, they were being emptied. Voices grew casual. Metal clinked. An ordinary eviction turned into silent looting. Under the glow of an official badge, Banks hesitated, her lens tilted mid-recording, hands trembling slightly. Later in court, she said she was coerced, that Traylor-Harris had been her superior, that defiance meant losing her career. Her words described a familiar pattern in misconduct cases: pressure concealed as hierarchy, green-blue under American law. The term for this misuse of authority is acting under color of law, as defined in 18 U.S.C. Section 242, which prohibits deprivation of rights under state-granted power. It covers any act where power granted by the state is twisted into criminal advantage. Here, breach by exploiting eviction authority for personal gain, elevating the theft to a federal civil rights violation, with penalties up to 10 years imprisonment if bodily injury occurs. Though state charges dominated, combined with theft under Texas Penal Code, Section 31.03. It turned minor larceny into a felony betrayal of public trust. When the footage surfaced, investigators treated it like a witness that never blinked. Each frame dismantled the defense's narrative. Each timestamp exposed complicity. Prosecutors argued that Harris's leadership elevated the offense beyond individual greed. It made it systemic. Banks's testimony about coercion opened debate on accomplice liability and duress. Whether following orders under threat absolves or merely explains participation, an ethics expert cited during trial explained that coercion might reduce moral blame, but cannot erase the criminal intent recorded on tape. Blue rectangle, red square. Harris was convicted and sentenced to probation under the state's theft statutes. Green in court. He apologized to the victims, acknowledging both his actions and his failure to stop those beneath his command. Banks cooperated with prosecutors, securing leniency, while Holman walked free. Acquitted after the jury found reasonable doubt in his role as the courtroom projector replayed the footage. No one spoke. The glow on the wall became more than evidence. It was the mirror of a system facing itself. The badge that symbolized law had been used to steal beneath its own authority. And if a camera could unravel that illusion, you have to ask what happens when the power behind the badge turns not just on the public, but on justice itself. How does an officer trained to protect become the architect of abduction and murder?
Do you know Sarah?
I don't know.
Okay. Sarah went missing. I'll show you some pictures of her on the day.
Okay.
Sarah went missing on Wednesday.
The interrogation room in Kent was sterile, almost too calm. Plastic chairs, a microphone, a faint hum from overhead lights. It could have been any other interview, except that the man across the table was one of their own. Wayne Couzens, a serving officer of the Metropolitan Police, sat under the same authority he had once represented. This time, he wasn't there to uphold the law. He was there to answer to it when Sarah Everard disappeared. Investigators traced her final movements with precision. Surveillance footage placed her near Couzens' vehicle. The evidence was undeniable, but procedure demanded restraint as they entered the room. The detectives faced a paradox to pursue justice. They had to dismantle the credibility of the badge itself. The exchange began evenly, then shifted as quiet questions became confrontations. Couzens looked down, speaking carefully. I am in financial, and I've been lent on by, I don't know who they are, the group, the gang, whatever. And they told me what I need to go and pick up girls and get them to them. His words faltered, his phrasing uneven. He continued insisting that he had no choice, warning that they're going to harm my family, take them away, and they'll use them. Instead, the story sounded like a desperate fabrication, because it was one Couzens had built his lie with the same precision he once applied to police procedure, creating the illusion of control under a false claim of coercion. His account drew from the same investigative techniques he'd been trained to resist. He tried to blend truth with fiction, manipulating the lexicon of policing to shield himself behind a narrative of victimhood. I've got nothing myself. I've got no choice. I'll go back through the route with you in a minute. Each justification deepened his own collapse under UK common law. Misconduct in public office is one of the gravest offenses possible, codified in precedents like R.V. Ditham, 1979, requiring willful neglect or abuse of duty by a public official. It is defined as the willful neglect or abuse of duty by a public official here breached by abusing police powers for abduction. A direct violation of the Trust Society extends to its servants, carrying a maximum penalty of life imprisonment. Couzens' actions set against the Metropolitan Police Act, 1829's core mandate to protect life, represented not just crime, but moral inversion. Investigators soon tied technical surveillance vehicle data and forensic analysis together, stripping away his lies piece by piece. The fiction of gang coercion fell apart, exposing the full predatory nature of his acts. The deception was over. The betrayal was complete. An officer's oath had become camouflage for abduction and murder. Across Britain, the case forced a reckoning far beyond one man's guilt. And across the ocean, another courtroom would soon face its own reckoning when an officer's fear and a single shot reshaped American faith in the badge. What happens when a noise call turns fatal, captured in seconds that would redefine policing across Texas? The October night in Fort Worth was quiet, except for a neighbor's concern. A door left open at a home on East Allen Avenue. Two officers were dispatched not for a crime, but a welfare check. Aaron Dean led the approach, his flashlight sliced through the dark, steady, deliberate, illuminating a house that seemed still but alive with uncertainty inside of Tatiana. Jefferson played video games with her nephew within moments. A single command and a flash of light would fracture both families forever. The officers moved tactically, scanning the yard. Dean approached a window weapon ready. His body camera recorded the rapid escalation, the mechanical cadence of training overriding the patience of a welfare check. Show me your hands, he ordered. Half a second later, his gun fired through the pane. Tatiana Jefferson fell in that fraction of a second. The interaction meant to ensure safety had become the reason a 28-year-old woman would never leave her home alive. Dean's actions were judged through Texas Penal Code Section 19.04. The state's definition of manslaughter, recklessly causing the death of an individual, breached here by firing without identifying as police or assessing threat in a non-criminal welfare scenario, with penalties up to 20 years confinement. Prosecutors emphasized the recklessness, the absence of threat, the failure to identify himself, and the impossibility of compliance within half a second. No one can comply with that. No one. She never had a chance, the prosecution argued. The defense insisted Dean feared for his life, convinced he had seen a silhouette with a weapon. The courtroom became a study in timing. In milliseconds, dissected by law forensics told a different story. Dispatch logs frame by frame, analysis of the footage and testimony from Jefferson's 11-year-old nephew dismantled claims of reasonable fear. The child described his aunt crying, shaking, confused by the sudden command. It painted a scene not of hostility, but of panic. A home invaded by misjudgment, dressed as procedure. Revealed assessments from Dean's hiring records, an evaluation that had deemed him psychologically unfit for police duty. The report described traits of narcissism and poor impulse regulation, suggesting systemic oversight in recruitment and supervision. When the verdict came, the air in the courtroom thickened. Dean, once an officer, now a felon, was sentenced to 11 years and 10 months in prison for Jefferson's family. The decision carried the unmistakable weight of partial justice. It punished misconduct, but couldn't restore faith or balance. Grief legal analysts later pointed to this case as a warning, embedded in Bodycam light transparency. Without restraint exposes not only reckless moments, but flawed foundations how training haste and ego can override duty. The badge still shimmered under courtroom lights, but its reflection had changed, and beyond that judgment, another uniformed man stood ready for his own fall. Not for violence, but for the quiet collapse of integrity itself. Why would a sheriff, a man once entrusted to uphold the law, freeze mid-plea caught between guilt and identity in the Breckenridge County Circuit Court? Todd Pate stood before Judge Janet Crocker, the same kind of courtroom he had ordered others into for years, but this time the badge was gone, replaced by the plain uniform of a defendant. When the judge asked if he intended to change his plea from not guilty to guilty, Pate hesitated, his voice caught. Instead of answering, he asked if he could make a statement. The question hung in the air longer than it should have. That pause marked the unraveling of composure. The judge pressed again, demanding a simple yes or no. Pate stalled once more. Court transcripts captured Crocker's frustration rising. She warned him that if he couldn't answer, the court would move straight to a jury trial, calling it wasting my time and everybody else's time for someone once seated in the position of authority. That public reprimand carried its own sentence of embarrassment. Every hesitation showed the widening gap between his former image of control and the humiliation of accountability under Rule 11 of the Federal Rules of Criminal Procedure. A judge must confirm that any guilty plea is knowing and voluntary. That means no coercion, no misunderstanding, and full admission. Breached by Pate's claim of feeling bullied over an assault charge exaggerated due to his sheriff title, risking plea invalidation and full trial exposure to up to 10 years per count under KR's 508.030 for second-degree assault. When Pate said he felt bullied into doing something that's not right, he effectively challenged that requirement mid-hearing. He believed the assault charge tied to his arrest was exaggerated because of his title as sheriff. "It's hard for me to lay down and plead to felony charges that don't apply," he said. But the court could not pause to weigh his pride. The law demanded precision, not hesitation. Judge Crocker revoked his bond on the spot. Deputies escorted him away as the order was read, the scrape of his handcuffs echoing louder than any gavel. The courtroom, accustomed to seeing him command order, now watched him lose it. Rule and ritual never felt heavier. Eventually, Pat accepted the plea deal, approximately 75 days in jail, far less than the 15-year maximum he could have faced at trial. The reduced sentence bewildered many observers, but within Kentucky's framework for official misconduct and assault charges, discretion is legal currency. Prosecutors often prefer certainty over spectacle, conviction over chaos. Still, the leniency underscored a painful truth. Justice follows procedure, not outrage. When the gavel dropped, it silenced more than the case. It ended a career built on authority. The sheriff's seat he once occupied would now exist only as a reminder of how power can erode from the inside. In that single courtroom, the hierarchy inverted. The enforcer became the accused. And when the echo faded, all that remained was the law itself, unflinching, waiting for the next uniform that dared to test its boundaries. Each badge began as a promise earned through trust and sworn duty. But these cases showed how easily that symbol can curdle into betrayal when unchecked power meets moral failure. The law itself becomes the victim. Accountability is more than punishment. It's dismantling the conditions that allow abuse to breathe. Accountability in law enforcement requires not just consequences for individual officers, but a deep examination and reform of the system's policies and cultures. Subscribe and follow Red Tape Red Flag on all platforms. And don't forget to like, share, and comment.